Sorry, go ahead.
And so there really is nothing to be gained from trying to convert these nouns into verbs. There is no single consistent way.
So if I accept that textual reading, and I also even start by accepting your argument that the Postal Service or the postal exception immunizes intentionally caused losses and miscarriages, those harms happening to people could be intentional. Let's say I start there. I guess I don't understand why all of Ms. Konan's claims here would be immunized under that exception. She has 4 claims here, only potentially one of which, it seems to me, even relates to the failure of her mail to arrive as the gravamen of her claim. The way we think about torts is people are bringing claims alleging that wrongful conduct or, negligent conduct by the defendant is a breach of a duty of care that has harmed them or breached a duty that harmed them. And I guess what I'm suggesting is that she's got claims here that really aren't about the loss of the mail, right? So they're not keyed to the failure of her mail to arrive. So the intentional infliction of emotional distress claim, for example, seems related to her claim that postal employees carried out a campaign of racial harassment with respect to how they treated her mail. And yes, we have the "my mail never arrived" is an allegation, but that's not her claim when it comes to intentional infliction of emotional distress. So I'm wondering why, even if you're right, she doesn't get to go forward on at least that claim.
So we think this is an issue that can be left on remand. The principle we're trying to vindicate here is simply the legal standard, and I don't think the court really needs to.
So you're not saying that Postal Service knocks out her IIED claim?
We're not asking the court to decide that. I think that's an issue that can be left for remand. On remand, we will make that argument, and we'll also make the argument that respondent has forfeited any contention.
All right, so going to the particular argument of a claim, assuming she has a claim in her complaint that actually is about the mail not arriving, as opposed to her IIED claim or her tortious interference claim, those seem like they're talking about other things. I guess I go back to Justice Sotomayor's suggestion that your argument indicates that Congress would have intended to immunize a Postal Service worker who tears up a person's rent check or Social Security check in front of them on their porch right there, intentionally. So it didn't, it doesn't get delivered, and you're saying yes, that's in the exception.
Yeah, and I don't think that should come as a surprise. Congress immunized all sorts of intentional conduct in the FTCA's exception. So in the intentional tort exception, it immunized assault and battery and misrepresentation.
Yeah, but there has to be a reason that makes sense. And so the whole thing is Congress, the FTCA is Congress authorizing tort claims to be brought against the government. This is an exception, and so the exception kind of has to make sense. And I guess what I'm trying to figure out is why Congress would have, we understand why Congress would have wanted to immunize negligent loss of the mail, miscarriage. First of all, that happens all the time.
Right.
And you could imagine a rational Congress saying, we just can't run a post office if everybody whose mail, catalog didn't get delivered can sue us. So we're not going to allow that. That makes perfect sense. What is hard to get one's mind around is in a statute in which Congress was authorizing tort liability, that a classic scenario in which the mail is actually being intentionally damaged, lost, not delivered, they also meant to take that off the table.
Two points. One is that respondent's rule is so broad in how it identifies intentional that it would encompass not just the willfully malicious hypos that Your Honor gave, but also routine application of postal regulations. Every day, the Postal Service intentionally withholds mail, either because it can't identify the addressee, because it thinks a residence is vacant, because it thinks the mail—
I understand, but the question is which overbroad rule are we going to go with? You're saying because that's the case, we should allow the tear up scenario to occur, that Congress could have wanted that. And I guess I don't understand why
that gets to my next point,
Yeah.
which I think as to the egregiously willful conduct, Congress, if I may finish, Mr. Chief Justice, Congress made the same judgment in the postal exception as it did in the intentional tort exception, and indeed some of the other exceptions that are far broader than the postal exception, which is that these damages suits aren't a good way for identifying who the bad actors are. It may well be that there are allegations that something willfully wrong happened. We're going to want to present evidence to refute that. It's going to be burdensome to the Postal Service and to other parts of the government, and Congress didn't think this was the right way to go about identifying those cases.